Hi everyone, welcome back to SR Knowledge Center. As I said yesterday, today I am uploading our first video and I am starting our classes with the subject Constitution of India. I had selected this subject because of the significance enjoyed by this subject. Whether we are preparing for an exam or not, being a citizen of this country, all of us must know some fundamental things in the Constitution, like what are the rights granted by the Constitution and what are the duties we have to perform, and we have to know some basic things related to functioning of the government. We will discuss all these things in detail. I will start my classes at scratch and I will take you to the top. Simply it means from zero level to hero level. But before diving into the subject, I want to inform one thing to all of you. There is a Telegram channel link in the description. Join to that channel. There we will provide PDF of this class. In that PDF we will provide some short notes of this class, which is very helpful for revision purpose. Or you can simply search SR Knowledge Center in the Telegram itself, and there you will get the channel, so directly you can join there also. Now without any delay, let's start today's class, and the topic for today's class is Introduction to Indian Constitution. In this class we are going to understand the nature of the Indian Constitution. But before going to talk about the nature of the Indian Constitution, let's understand what is a constitution and what are the various types of constitutions. And in that, the first thing is, what is a constitution? Constitution is a supreme law of the land which enjoys the special legal sanctity. So in this sentence we have two phrases. One is constitution is a supreme law of the land, and the second thing is it enjoys the special legal sanctity. So first of all, understand the first phrase, that is constitution is the supreme law of the land. What does it mean? In every country there is a legal hierarchy. In that, the constitution stays at the top. After that, we have the laws passed by the parliament, and then we have the rules and notifications issued by the government. And in this hierarchy, constitution is at the supreme position. That's why we will call constitution is the supreme law of the land. And the second phrase talks about it enjoys the special legal sanctity. So understand what is a special legal sanctity. Just now we had discussed legal hierarchy. In that, constitution is at top. After that we have laws made by the parliament, and after that we have the rules and notifications issued by the government. In that, the constitution can violate the laws made by the parliament, and at the same time it can violate the rules, or we can say notifications issued by the government. But on the other hand, the laws made by the parliament or the notifications issued by the government cannot override, or we can say cannot go against the constitution. That thing we will call a special legal sanctity. Simply it means constitution has the power to go against the laws as well as go against the notifications issued by the government. But these laws and at the same time these notifications cannot go against the constitution. That is the special power which is entrusted to the constitution, and that power we will call as special legal sanctity. Let's understand this furthermore with a small example. There is an act known as Information Technology Act 2000, which is the act enacted by the Parliament in the year 2000 to regulate and control digital space, or we can say cyberspace in India. And in that we have section 66A, which says that if anyone by using an electronic device transmits any message, and if that message causes annoyance to any other person, in such case the sender will be imprisoned up to 3 years. But this section fails to describe type of messages that can be caused annoyance. Due to this deficiency, innocent people were booked under this section and they were punished. And there is a girl, her name is Shreya Shingal. She is a law student. She filed a case in the Supreme Court asking the court to strike down Section 66A, stating that it is the violation of fundamental rights mentioned under Part 3 of the Constitution. We will discuss all these fundamental rights after a few classes. But for the time being, for your understanding, I will give a small introduction about fundamental rights. In Part 3, Article 19, Clause 1, Clause A says that everyone has the right to free speech and expression. But this section is barring that free speech and expression. So, she went to the Supreme Court requesting it to nullify that section, that is, requesting it to struck down that section, and the Supreme Court agreed with the arguments of the Shreya Shingal and it has struck down Section 66A of Information Technology Act 2000 as unconstitutional. And with this example, we can understand that no law or notification issued by the government can violate the Constitution. That is called as a supreme law, or we can say special legal sanctity. But on the other hand, Constitution can violate all these things. Any laws made by the parliament or any notifications issued by the government, but vice versa is not possible. And now the second point is Constitution is a document which describes the powers and the functions of the organs of state. So here state means not the state like Andhra Pradesh, Tamil Nadu, it is not that state. Here state means a country, and Constitution is a document which regulates the organs of state. Every state has three organs. One is legislature, executive and judiciary. If we understand the functions of these organs, then legislature will make laws and the executive will implement those laws and the judiciary will administrate the justice to the people, and also it is the guardian of the Constitution. So if any law is against the Constitution, then Supreme Court will immediately strike down that law, stating it as a unconstitutional. Here we have to understand one thing. While exercising the powers, one organ of the state will interfere into another organ. Always there is a fight between all these three organs. Like legislature wants to control executive and executive wants to implement its own rules rather than the laws made by the legislature. In that way, there is always a conflict between these three organs. But for a state to function smoothly, these three organs has to act according to the powers and functions mentioned in the Constitution. And Constitution prescribe various rules and regulations, and also it mentions the powers and functions of these three organs. So by following the provisions mentioned under the Constitution, these three organs has to function with their own domains only. They cannot interfere with the another organ's functions or powers. Now come to the third point. Constitution is a document which reflects the faith and aspirations of the people. And for that, for understanding this point, we have to touch the history a little bit. India is ruled by the Britishers from 1757 till 1947, but they never think about the aspirations of the Indians. Their only motto is to maximize their wealth and to have a firm grip on this country, but they never put any efforts to fulfill the aspirations of this country. But after we get independence, our constitutional makers feel that it is the time to implement the aspirations of the people and the faith which they put on the Constitution. Based on those aspirations, the framers has included ideals like liberty, freedom, equality, justice. It may be economical justice, social justice, political justice. So all these ideals were mentioned in the constitution. But when Britishers ruling India, they never had any intention to provide all these things like freedom, liberty, justice to the people of this country. And with this, we have completed what is a constitution. And the 3 points are: constitution is the supreme law of the land which enjoys the special legal sanctity. And then what is a constitution? In that case, we can say that constitution is a document which governs the three organs of the state. And then if what is a constitution? In that case, we can say that constitution is a document which reflects the faith and aspirations of the people. Now let's understand various types of constitution, and along with these types we will understand what is the nature of the Indian constitution. For an example, we have where the types of constitutions are written constitution and unwritten constitution. We have enacted constitution and we have evolved constitution. We have unitary constitution, we have federal constitution. So now let's understand each of these types one by one. Now let's start with the first type, written constitution and unwritten constitution. After reading these words, don't think a written constitution is written on a paper and an unwritten constitution is not written on a paper. Don't think like that. Both constitutions are written on a paper only. Then what is the difference between these two things? We are going to understand now. In a written constitution, all the provisions are codified into a single document. But in an unwritten constitution, all the provisions are not codified into a single document. Let's understand this furthermore with examples. So if we take the examples for a written constitution, then United States of America Constitution and Indian Constitution are the examples for written constitution. And if we take the examples for unwritten constitution, then Constitution of England and Constitution of New Zealand. These are the examples of the unwritten constitution. Now understand these types with examples. Here, if anyone asks me to bring the Constitution of US, then simply I can bring a paper, because US Constitution has only 7 articles and those 7 articles is codified into a single document. And in the same way, if anyone asks me to bring the Constitution of India, then I can bring a book. Indian Constitution has 395 articles and all these 395 articles are codified into a single document, that is a single book. But on the other hand, if anyone asks me to bring the Constitution of England, I have to bring so many books, because the Constitution of England is codified, but it is not codified into a single document. We have various laws, or we can say we have various documents for various aspects of the Constitution in England. But when we come to India and US, all those aspects, we can say all those provisions related to government and fundamental rights, fundamental duties, all these things are codified into a single document. But in England, they are under different legislations. That is the difference between a written constitution and an unwritten constitution. In a written constitution, we can get all provisions in a single document. But in an unwritten constitution, we cannot get all provisions in a single document. We have to look for various documents, that means various enactments. And one more difference is, in a written constitution, constitution is the supreme, but in an unwritten constitution, parliament is supreme. Simply it means in a written constitution, parliament cannot pass any laws against the constitution, because constitution is the supreme. But in the England, that is in unwritten constitution, parliament is the supreme, so it can make any law. That's why there is a famous saying, or we can say famous quotation, that is UK Parliament can do anything except changing the men into women. That means it can pass any law. But on the other hand, Indian Parliament or US Parliament is not allowed to pass any law. If they pass any enactment, it has to be an agreement with the Constitution. Simply it means the law passed by the Parliament of India or the Parliament, or we can say it is Congress and Senate. The laws made by these two legislations cannot be more than Constitution. Now let's move to the second type, that is enacted constitution and evolved constitution. Now understand enacted constitution. An enacted constitution is a constitution which is drafted by a single body and it comes into force at one go. Let's understand with the example. Indian constitution is example for an enacted constitution. So if you understand the phrase, that is enacted constitution is drafted by a single body and it comes into force at one go. So it means Indian constitution is drafted by a constitutional assembly. It is a single body. And the constitution came into force on 26th January 1950. That means it came into force on a single go. In the similar manner, if we talk about US constitution, it is also drafted by a single body and it came into force in the year 1789. But on the other hand, if we talk about evolved constitution, these are the constitutions evolved over a period of time. If we take the example, it is the it is England. Because England constitution is not drafted by a single body and also it is not came into force at one go. It has evolved over a period of nearly 8 centuries. The first constitutional provisions, or we can say constitutional law made in England, is Magna Carta in the year 1215. It has ended the absolute monarchy of the Queen or King and introduced the constitutional monarchy. Understand these two terms. An absolute monarch can do anything, but a constitutional monarch can do anything but within the limits of the constitution. So till 1215, Britain king is absolute monarch, like King of Saudi now. He can do anything. He can execute anyone. He can change the constitution. He can do anything. But on the other hand, if we talk about constitutional monarch, he also can do anything but within the limits prescribed by the constitution. And in the 1215, there is a revolt in the England, and at that time the king ended his absolute monarchy and he created a law which is known as Magna Carta, which later became almost the constitution of England. After Magna Carta, so many laws were made over a period of time. That's why it is a evolved constitution. When we talk about the Constitution of India, it's a enacted constitution because it is created by a single body which is known as Constitutional Assembly, and also it came into force at a single go, that is on 26th January 1950. Now let's move to the next type, that is Unitary Constitution or Federal Constitution. First of all, let's understand what is a Unitary Constitution. In a Unitary Constitution, all the powers are concentrated at a strong center, but that doesn't mean there is no local bodies or no local governments. Yes, there are local bodies and local governments. If we take the example, then the UK is the example for Unitary Constitution. The powers all are concentrated at the center, which is in London, and there are some provinces, they have their local governments, but their powers are delegated from the central government. But in a federal constitution, powers are not delegated, they are distributed. Understand these two phrases, then only we can understand the difference between unitary and federal constitution. So, in a delegated power, the person, or we can say the authority who delegated that power, can revoke that power at any time. Simply, if we take the example of England, there we have the government in London, which is a central government. It has delegated some powers to the local bodies for like sanitation, administration, all these things. But in any time, that means at any point of time, the government at center can revoke these powers, and it can transfer these powers to itself or to some other person. But if we talk about distributed powers, then the example is India. In our constitution, under Schedule 7, we have three lists: state list, central list, as well as concurrent list. We can say union list, state list, and concurrent list. On union list, only the central government can make the laws. On the aspects mentioned in state list, only the state government can make the laws. On concurrent list, the both central and state governments can make the laws. But in a normal circumstance, central government cannot make the laws on the state subjects, and at the same time state government cannot make the laws on central subjects. This is the powers distributed. So here powers are distributed between the center and state governments. So each one cannot interfere into the powers of other government. That is, center cannot interfere into state powers, and at the same time states cannot interfere into central powers. But in an unitary constitution, center alone has all powers, and it will delegate some of their powers to the local governments for the purpose of administrative convenience. Now let's understand what is a federal constitution. But here we have a difficulty. We can define written and unwritten constitutions. We can define evolved and enacted constitutions. Even we can define an unitary constitution. But defining a federal constitution is not possible. There is no clear definition for a federal constitution. Then how to understand what is a federal constitution? In that case, we can say for that we have to depend upon the Constitution of United States, because almost all constitutional experts has accepted Constitution of US as a federal constitution, and if any other constitution matches with the Constitution of US, then we can say it as a federal constitution. Because of any reason, if any other constitution fails to match with the Constitution of US, we will not call it as a federal constitution. We will call it something else. While matching the any other constitution with US constitution, we have to match, or we can say we have to understand the following parameters. In that, first one is dual government. There must be a government in the state, and at the same time there must be a government at union level or at central level. Then only it can be treated as a federal constitution. So if we take the example of a US, then there is a federal government which is situated in Washington, and each of every state, that is US have 50 states, and each state has its own state government, like state government of California, state government of New York. So every state has its own state government. And the second parameter which we has to match is the distribution of powers, because in a federal government there must be distribution of powers between the center and state. Just now we had discussed Schedule 7. So Indian Constitution also distributed the powers between the center and the states, and even the US constitution distributed the powers between the center and states. So the central aspects, only the federal government can make laws. On the state aspects, only the state governments like government of New York, government of California, these can make the laws. There is a clear distinction between their powers, and they are properly distributed in the constitution itself. And the third parameter which we has to match is it must be a written constitution, because only a written constitution can become a federal constitution. And the reason is, if it is unwritten constitution, in that case parliament is the supreme. So parliament has all the powers. That means the powers are concentrating at a center. That's why it cannot be become a federal constitution. Only a written constitution can become the federal constitution. And only a written constitution can distribute the powers, because in an unwritten constitution the parliament can change these powers at any time. So there is no distribution of powers in an unwritten constitution. Even though there are distribution of powers, they can be scrapped at any time by the parliament, but in a written constitution that is not possible. And the next parameter we have to match is rigidity of the constitution and supremacy of the constitution. First of all, understand what is rigidity of the constitution. Generally everyone will think that rigidity means the process for amending the constitution should be very tough, but actually it is not the meaning of rigidity. The rigidity means for amending the constitution, it must be a comprehensive, or we can say a mutual effort of the central and state governments. Simply it means amendment of constitution must be a common effort or a common act of center and the state governments. Supremacy of the constitution we already discussed. In a legal hierarchy, constitution stays at the top. We already discussed that point. In a federal constitution is always the supreme. That means the parliament cannot amend cannot violate the constitution. It can amend the constitution, but the laws made by the parliament should not go against the basic principles of the constitution. And the last point is independent judiciary. One of the key feature, or we can say one of the key parameter for deciding a federal constitution is independent judiciary, because only when there is an independent judiciary it can act in balance between the center and state by following the constitutional provisions. When the judiciary is not independent, if it is biased to a central government or if it is biased to a state government, in that case we will not treat it as an independent judiciary. The independent judiciary shall be the guardian of the constitution, and it shall ensure the state and the center has to perform their functions based on the provisions mentioned in the constitution. They have to perform their functions and powers according to the constitutional provisions. With these 5 parameters, we can say US Constitution is a federal constitution. Now understand the nature of Indian Constitution, whether it is a unitary constitution or whether it is a federal constitution, by matching all these 5 parameters. Now understand the first one, that is dual government. Whether India has a dual government? Yes, India has a dual government. We have central government in the Delhi and we have state government in each state. Second point is distribution of powers. Whether we have distribution of powers? Yes, we have distribution of powers. Just now we had discussed there are 3 lists in the Schedule 7, that is Union list, state list and concurrent list. According to these 3 lists, we can say that there is distribution of powers between center and the states. Now the third point is written constitution. Whether Indian constitution is a written constitution, yes, it is the longest written constitution in the world. It has 395 articles divided into 25 parts and 12 schedules. Now understand the fourth point. The constitution must be rigid and it should be supreme. Whether it is a rigid, whether Indian constitution is a rigid, yes, for amending the aspects related to federal structure and the aspects related to taxation like GST, the central government need the permission of the state governments to amend all these aspects. With this, we can say that Indian constitution is rigid also. Whether it is a supreme, yes, because any law passed by the parliament has to be in consonance with the constitution. If any law violates the constitution, then the Supreme Court or High Court will struck down those acts or provisions. And the last point, that is fifth point, or we can say fifth parameter, is independent judiciary. Whether we have independent judiciary, yes, we have. So all five parameters are matching with the constitution of US. So are we say we can whether we can say Indian constitution as a federal constitution? No. Understand why. Again, come to the first point, that is dual government. Is India have a dual government? Yes, we have. But the central government can scrap the government in state at any time by imposing Article 356, that is state emergency, or an emergency under Article 352, which says about the national emergency. So simply it means even though there is a government in the state, it is not strong enough to fight with the center. But in US, the state government cannot be suspended. Now understand the second point, that is distribution of powers. Whether we have distribution of powers, yes and no. Why it is no means when there is a state emergency or when there is a national emergency, all the powers mentioned in the state list can be executed, or we can say the central government can make laws on the subjects mentioned in the state list. That means even though there is a distribution of powers, it is biased towards the central government. Now move to the third point, written constitution. Whether India has a written constitution? Yes. But are the state consulted at the time of writing constitution? No. Only states has representation in the constitutional assembly, but the states were never consulted when they are writing the constitution, and we have more than 560 princely states at the time of independence. They are simply annexed to the country, but they don't have any involvement in the constitutional writing. Even though it's a written constitution, states has never involved in that procedure. So with that we can say it is not a federal constitution. Now match the fourth point, that is rigidity of the constitution. Whether Indian constitution is rigid, almost 90% of the aspects can be amended by central government alone without any consultation from the state government. Like the central government can bifurcate any state, it can amend fundamental rights, directive principles, fundamental duties, and similarly it can amend so many things without the permission of the state government. Only in a few circumstances, the central government need the permission of the state government for amending various aspects. With this, we can say Indian constitution is not rigid as much as the constitution of US. Now come to the last point, that is independent judiciary. So whether judiciary in India is independent, yes and no at the same time. It is no because who are appointing the judges of the Supreme Court and High Court? The central government and the president, with the recommendations from the Prime Ministry, the President will appoint the judges of the Supreme Court and High Court. That means state has no involvement at the time of appointing the judges. So we can say with this we can say the judiciary is slightly biased towards the central government, because the central government will appoint its favorites in the judiciary. State governments has no involvement in the appointment of judges to the High Court or to the Supreme Court. After all this analysis, we have a confusion whether it is a federal constitution or whether it is a unitary constitution, because Indian constitution is following the both principles. Sometimes it is federal, sometimes it is unitary. So how to define Indian constitution? For that, the answer is Indian constitution is a quasi-federal constitution. Now understand what is a quasi-federal constitution. Simply it means the Indian constitution has the features of unitary constitution as well as a federal constitution, but it is biased towards the federal constitution. That's why we will call it as a quasi-federal constitution, because in normal circumstances Indian constitution is federal, but when there is emergency, like when there is a circumstances of war, external aggression, or we can say armed rebellion, so when these kind of situations are in existence, then the constitution becomes into unitary constitution. And at the same time, when there is breakdown of constitutional machinery in a state, in that case only the central government can scrap the government in the state government. Simply it means in a normal circumstance, the Constitution of India is federal, but in case of emergencies, it is unitary constitution. That's why it is known as quasi-federal constitution. Now with this we have came to an end of this session. If we have a brief analysis of this class, in this class we had discussed what is a constitution, what are various types of constitutions, and we had also discussed what is the nature of the Indian constitution. And from tomorrow we will start various provisions of the Indian constitution. Simply, Indian constitution has 395 articles, 8 schedules and 22 parts at the time of enactment, but now it has around 450 articles divided into 25 parts and 12 schedules. From tomorrow we will discuss each and every part, each and every article in detail. Like we have part 1 talks about union and states, part 2 talks about citizenship, part 3 fundamental rights, part 4 directive principles, part 4a fundamental duties, part 5 union government. In that we have 25 parts, and all these parts combinedly had 448 articles. We will discuss all these articles and parts and schedules in detail. And with this we have concluded this session, and don't forget to download the PDF which is provided in SR Knowledge Center Telegram channel. We have provided the link in the description. And if anyone have any doubts or suggestions, please post in the comments. We will try to address as many as possible. Thank you for watching this video. Please like, comment, share this video, and please subscribe to SR Knowledge Center for supporting our initiative.